Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Before we take the roll, members, when your name is called, if you could please hit your microphone button and state that you are here in your microphone. That'll make sure it's picked up on the audio. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen. Here. Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
It's working. It's working.
Here.
Assemblyman Orntlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Sorry, I was on mute. Here.
Chairman Yeager.
I am here. Everyone is present. That means we do have a quorum. Good morning, everyone, and welcome to day 74 of the 81st session of the Nevada Legislature, and welcome to our first day of in-person committee hearings. It is indeed good to be in the room with all of you. Before we get started, we'll go over just a couple housekeeping matters, and some of these will be new since we are in a room together. For members of the committee and guests who are here in the room with us, if you could please make sure to silence your devices. That will help us tremendously. And then for anyone who is in the room today who may be testifying on a bill or presenting a bill, when you come to the table to do that, if you could please remember to turn the microphone on, to state your name, provide your testimony, and then remember to turn the microphone off after you are done speaking. For guests who are on the Zoom with us today, if you could remember to mute yourself when you're not speaking, that'll help with the audio feedback. And if you could also remember to state your name each time before you speak, particularly when you're asked a question, that will help us prepare accurate committee minutes. Members of the committee, as you know, we need to make sure we're treating each other with courtesy and respect, even if we disagree on policy. And we expect that for members, for those who are testifying from the public, and for our staff as well. And then finally, even though we're not virtual anymore, many of us have multiple devices in front of us to try to access this meeting. So please don't see it as a sign of disrespect or inattention if members appear to be looking at their devices throughout the meeting. I think that is all of our housekeeping matters. So members, we will move to our agenda this morning. And as you can see, we have 3 bills on the agenda. I am going to take them slightly out of order. So we're going to start with Senate Bill 357. At this time, I will open up the hearing on Senate Bill 357. Senate Bill 357 requires the Department of Corrections to track and report expenses that are directly related to housing youthful offenders. Joining us on the Zoom this morning, we have Senator Orrin, who was a member of this committee for 6 sessions, and it was an honor for me to be able to serve with him a couple of those sessions. So welcome back for the first time this session, Senator Orrin, and please proceed when you're ready.
Good morning, Chair Yeager, members of the Assembly Judiciary Committee. For the record, James Orrin. I represent State Senate District 21. That's parts of Henderson and unincorporated Clark County. And I had the distinct honor to be a member of your committee, to work with you, Chairman Yeager, and to serve as Vice Chair of the Assembly Judiciary Committee. And incredibly proud of the great work you're doing, and I'm proud to have been a former Vice Chairman of this committee. I had the distinct honor during the interim to chair the Interim Legislative Committee on Child Welfare and Juvenile Justice. We had a lot of work ahead of us. We had 2 in-person meetings at the Grant Sawyer building with teleconferences up here to the Legislative building in Carson City before the pandemic hit. After the pandemic hit, we had 4 virtual meetings. And I want to thank, Patrick Guinan, and Julianne King, Eileen O'Grady, Carly O'Krent, the tremendous staff at broadcasting who made that happen, because once COVID hit, we weren't really sure how we'd continue and how we'd carry on our business. But notwithstanding everything that we went through, we were able to continue with our next 4 virtual meetings and produce 10 different bill draft requests, as well as requests for letters from that committee. I think that most of our recommendations came out bipartisan and unanimous. I was very lucky to get to serve with Assemblywoman Monroe Moreno, who was Vice Chair of the Interim Committee on Child Welfare and Juvenile Justice, Assemblywoman Hanson, Assemblywoman Torres. And we worked very hard, and want to thank everybody for all their hard work. One of our recommendations you see in Senate Bill 357. We were tasked from Assembly Bill 449 of the 2019 session to try to look at the cost of housing young offenders. And, just to highlight for some of the new members on the committee, many people don't realize that there are juveniles, boys under 18 housed at the Lovelock Correctional Center. During the interim, we found out that there currently is not a Nevada Department of Corrections facility to house girls under 18 who've been sentenced as adults. And right now, the information we got is that they're being housed out of state. But our interim committee wanted to look at the cost of housing those children, those boys who are under 18 at the Lovelock Correctional Center. We wanted to look at the cost of education, communication, and interaction with family members, healthcare, mental health, recreational programming, and any other cost that the director of the Nevada Department of Corrections felt was special for those children. And those children who are up at the Lovelock Correctional Center, pursuant to the Federal Prison Rape Elimination Act, have sight and sound separation from the adults, but they are still there at that adult facility. And some of the concerns I've had and others have had, I know that the ACLU has had, is, in terms of the programming they're getting versus if they were at a juvenile facility with children their own age. And it's kind of hard to make those decisions when we struggle to get that information. And I want to thank Nevada Department of Corrections and Warden Garrett of Lovelock, who tried to get us as much information as they could get. But during the interim, we found that it was very difficult for them to separate their overall budget for the Lovelock Correctional Center as to what is being spent on the juveniles who are being housed there. And Senate Bill 357 is a recommendation out of our committee to try to get us that information so that during the next interim, when the Interim Committee on Child Welfare and Juvenile Justice meets again, they'll have this very important information to look at and to make recommendations to the next legislature. With that, I'm happy to answer any questions.
Thank you so much, Senator Orrin. Again, it's good to have you back in the committee. Committee members, do we have questions for Senator Orrin? We'll start with Assemblywoman Bilbray Axelrod.
Thank you, Mr. Chair, and thank you, Senator Orrin, for bringing this bill. I was shocked when we had early on in the session when we had folks from corrections talking about kids who are in this situation, and so thank you for bringing this bill. I'm just curious, in your work in the interim, how many kids are we talking about, both boys and girls? I know you said boys at Lovelock and girls are being sent out of state, and I'm just wondering how many, if you know that number.
To you and through you, Chair Yeager, to Assemblywoman Bilbray Axelrod. My recollection is that there were 3 juvenile females that were being housed out of state because currently there was no provision for them to be housed at the Florence McClure, our only female correctional center, Florence McClure Correctional Center down in Clark County. There was testimony during the interim that in the past, many years ago, there had been a juvenile female housed at Florence McClure. And then as to the boys housed at the Lovelock Correctional Center, I apologize, I don't have that information in front of me. I believe it's between 10 and 20, but I might be incorrect. And I think that there might be Ms. Wellborn from the Nevada ACLU is going to be calling in. She might have that exact number of boys that are currently housed at Lovelock. I know that it's fluctuated, and I apologize that I don't have that information. If she doesn't have that, I will get that to you and share with you and the committee, Assemblywoman Bilbray Axelrod.
We'll go next to Assemblywoman Cohen.
Thank you, Chair, and it's good to see you, Senator. My question has to do with the process for the juvenile prisoners. So, for instance, we've heard about issues with adult prisoners and the cost of communication with family members and phone calls and that type of thing. Are the juvenile prisoners, are they under the same cost system, or can you talk more about how their needs are met versus the adult prisoners?
To you and through you, Chair Yeager, to Assemblywoman Cohen. There was testimony during the interim from Nevada Department of Corrections as to how hard they do work to try to make sure that educational and mental health needs are met, trying to ensure that communication with family, with these children's family keeps going. As to the actual costs that are spent on whether it's phone calls or being able to do, if they're able to do a video call, that I don't have. I hope that, that might be information we'll get during the interim with this, but I don't have that information right now.
Thank you. And to be clear, I'm not necessarily asking what the cost is for the juveniles. I know that's what the bill is about, getting that information, but are they under the same rules and guidelines? So for instance, if adult prisoners are charged and the money comes out of their account for telephone communication with family members, is that the same thing with juveniles, or because they're juveniles, is that something that the state covers that cost, or how does that work?
Thank you. Through you, Chair, to Assemblywoman Cohen. That's a question I don't have the answer to. That's a very good question, and I would, that's something that we didn't find out during the interim as to whether families can put, money on children's books the way they could on an adult relative's book, so that they could call or buy something from the commissary at that correctional facility. So I don't want to give incorrect information. My assumption is that things like that would be similar, since these juveniles have been sentenced as adults, but they're there at the Lovelock Correctional Center with sight and sound separation. But I don't know that for sure, and I'll try to find out that answer to that question too, and let you and the chair and the committee know.
Thank you.
Thank you. And Senator Orrin, you don't have to go through me if you don't want to. I know you've been in the building a long time, and tradition is tradition, so feel free to go to the member directly if you would like. We do have some additional questions. I'm going to go next to Assemblyman Wheeler and then Assemblywoman Kasama. So please go ahead, Assemblyman Wheeler.
Thank you, Mr. Chair. Senator Orrin, good to see you again. Haven't seen much of you this year because of our sequester in our offices. But I'm wondering, sir, what the actual purpose of this is, what this leads to. Are we looking at maybe in the future, after reports like this, of changing the system so that there's a separation, et cetera? What are we going to get out of this?
Thank you very much. It's good to see you too, Assemblyman Wheeler. And I have been pretty sequestered up here trying to shepherd my bill, so I apologize. I haven't made too many trips over to the Assembly side yet, but hope to now. I think, knowledge is power, and I think this is very important information for the Interim Committee on Child Welfare and Juvenile Justice. What that next interim committee decides to do with it will be up to them. I can tell you my feeling is that diverting children out of adult prisons, adult criminal courts, leads to more positive outcomes for those children. And I think that there is a lot better programming for children in the facilities that are run by our Division of Child and Family Services, such as the Caliente Youth Center, Nevada Youth Training Center, Summit View Youth Training Center, that are where the number one focus is children, education, programming mental health needs, physical health needs, trying to rehabilitate those children so that they hopefully won't end up back in the system. So I think the knowledge is important to have. What the committee decides to do with it will be up to that interim committee during the interim. I personally feel that, having this information and being able to decide whether it's more costly to house a juvenile over at an adult correctional center or perhaps at a youth correctional center would be important information for the legislature to have, and it would be up to the interim committee and the next legislature to decide what to do with that information. The problem we had during the interim, couldn't really get a breakdown about the overall budget of Lovelock versus what is spent on those kids. And that's what we're trying to get.
Okay, thank you.
We'll go next to Assemblywoman Kasama.
Assemblyman Wheeler asked my exact question. I was just wondering what the end goal was, or, if what the thought was. But you've answered that, so they need the information to decide what is the best way in the future. And so I look forward to the results of that study. So thank you.
Thank you very much. And there's a lot of information we went over during the interim in terms of the new developments in brain science and how a child's brain doesn't fully develop, I think, the frontal cortex till they're 25. Many of the children who've been sent to the adult system there's no question, very, very serious crimes that they've been charged with. But many of these children have been the victim of abuse and neglect. They've had very unstable upbringings. They, may not have known, whether they'd have a roof over their head, whether, the parents might be incarcerated themselves or have lost a parent. And there's a lot of that can be done, I believe, for these children in a better fashion, not in an adult correctional center. And that's not what this bill does. This bill doesn't change that, but this bill would at least let us know the cost of housing these juveniles in an adult facility.
We'll go next to Assemblyman O'Neill.
Thank you, Chair. Senator Orrin, how are you doing today, sir? It's a pleasure to see you again.
Good to see you too, Assemblyman.
Couple quick questions. I'm really disappointed that DOC cannot already have this in their line item budgeting on what it costs when the children have to be separated from the adults anyways at Lovelock. So I find that really disappointing. Whoops. And I understand the need for it. I truly do. The questions I have is, do we need this in statute? Will this be an ongoing every year? Or once we get the information for the interim study, will they need it following year, the following year, and the following year? That would be my question. Could it just be a requirement that the governor asks or is required to submit to the governor without statute? We only meet every 2 years, as you well know. We put something in statute, and then we've got to come back in next session to remove it.
Thank you for the question, and certainly, during the interim, our committee was appreciative of all the help from Nevada Department of Corrections, but this is information that we really, really needed, and it would have been important for us to have. And I believe that Senate Bill 357 is the right way to go, to ask that this information be produced, that we put it in statute, and that we get this information, in perpetuity, because certainly, since we've served, I think you and I, Assemblyman O'Neill, have served under 3 or 4 different directors of the Nevada Department of Corrections and different members of the boards of prison commissioners. And while it might be a priority to come up with this information for a particular director or a particular board of prison commissioners, it may not be for the next one. So I believe that this is the right way to go here, rather than ask that it be just a request, because unfortunately we weren't able to get that during the interim. So here, much as I agree with you, sometimes you don't want to fill up the statute books with too much stuff, but here I think this is something important so that future legislatures, future interim committees can have this information.
Thank you, Senator Orrin. Thank you, Chair, for the time.
Go next to Assemblywoman Krasner.
Thank you, Chair Yeager. Good morning, Senator Orrin. It's so great to see you. And I just wanted to say thank you for bringing this important bill for juvenile justice. I'm actually shocked that we don't already have this kind of information, so I wanted to thank you for bringing this bill. My only question is, why are we putting kids in with adults? I mean, don't they get attacked and assaulted and raped? Why are we still doing that? Thank you.
Thank you, Assemblywoman Krasner. It's great to see you too, and talk about great memories of serving on this committee and fighting for important issues in a bipartisan way. I certainly have great memories of working with you in a bipartisan way on a lot of important issues that we both cared about. And thank you for keeping up the good fight on so many of those issues. On the children who are up at the Lovelock Correctional Center have sight and sound separation from the adult inmates pursuant to the Federal Prison Rape Elimination Act. So there should be no contact with those children. What I believe would be important information for us to have as a result of Senate Bill 357 is the cost of housing those children in an adult facility. And then an interim committee, a future legislature, could look at the cost of housing those children maybe at a juvenile facility that is more geared towards programming for kids, for trying to make sure that mental health needs are met, that past traumas that those kids have suffered are dealt with. I'm sure that many of those children up at the Lovelock Correctional Center have witnessed someone die in front of them, oftentimes a relative. There's a lot that can be done for those children. And I think that if we know the current cost of housing them in an adult facility and then can compare it with the potential cost of housing them at a more child-centered facility, there's a lot better chance they're going to get the help, the treatment they need, and they're not going to be long-term residents of the Nevada Department of Corrections as young adults. So I appreciate the question, and I think that this information would be for future legislatures to have.
Thank you very much.
Assemblyman Orrin.
Thank you, Chair, and thank you, Senator, for your work on behalf of child welfare and for bringing forth this bill. I like the bill. I just have a small little question about where you list the different kind of expenses, and we have healthcare as C and mental health as D. And my concern is we often have problems with recognizing mental health as deserving parity with other kinds of healthcare. And so separating it out kind of reinforces that. On the other hand, I can see why you would want to have special attention to mental health costs because of the population. So is there a way to kind of not reinforce the parity issue while still making sure we collect this information specifically?
Assemblyman Orrin, I'm certainly open to changes in the language that you would suggest. You know, certainly during my time on the Assembly Judiciary Committee, we were never fortunate enough to have a law professor as a member of the committee. So if there's any language you think would improve the bill, I'm certainly open to that. Many of the children, my day job is a deputy public defender in juvenile court, and many of the children I see get arrested not only have untreated mental health needs, there's substance abuse issues. Sometimes kids are self-medicating, and a lot of times, as unfortunate as it is to admit, when a child is arrested and appears before the juvenile court judge, sometimes the orders the juvenile court judge is the first time that child gets some of the mental health care that they needed and was just going untreated. So I think here, if we can try to quantify what needs to be spent, what is being spent, and whether the children are getting the access to someone who specializes in mental health needs of children would be important, as opposed to someone who's maybe doesn't have that kind of specialization. But I certainly won't argue if there's some language you think would make this stronger.
Thank you.
Do we have additional questions from the committee for Senator Orrin? Okay, I don't see additional questions. What I would like to do, Senator Orrin, is have you sit tight for a moment. We do have a representative from the Nevada Department of Corrections on the Zoom with us. I believe it is Ms. Powers, and I thought it probably made sense to allow them a chance to answer a few of those questions that were asked that Senator Orrin was not able to answer. So at this time, I want to go to you, Ms. Powers, on the Zoom, and if you could answer any of those questions, and hopefully you've been taking good notes on some of those, but we can repeat them if need be. And welcome to the Assembly Judiciary Committee. Please go ahead.
Good morning, Chair Yeager. This is Deputy Director Harold Wickham. I apologize for the confusion on the name. I was at a dental appointment, but fortunately I got out early. So for the record, Harold Wickham. Thank you, Chair, and thank you, Senator Orrin for bringing this all-important SB 357 forward. I think I can answer some of the questions you have. So first of all, we have 11 males currently incarcerated, and I have to say males, juvenile males incarcerated at the Lovelock Correctional Center. We have one female offender who is currently housed in Arizona, and that's because we don't have a facility for juveniles, and our female facility it doesn't protect from sight and sound in accordance with PREA and our other separations to keep the offenders safe. So we have 12 offenders currently, one being a female housed out of state. And these offenders are certified by the court as adults. So they're actually treated the same. And let me clarify on that when I say the same. They're given the same privilege as available. They're giving the same opportunities, same store, same use of the telephones, same inmate accounts. All of it is treated the same. However, we do everything to ensure that these offenders are kept separate from adult offenders. So there's a unique pattern there. And I want to say that as an agency, we're happy to provide whatever data, whatever cost analysis you need. We're happy to provide that. And we actually think it's very relevant to provide that because we are in agreement. This is something that needs to be addressed. Frankly, kids shouldn't be in adult prisons. It's just not good for their psychological health. But as far as cost and data, we're happy to provide that. And I will tell you that the services that we do provide are unbudgeted. We do not have a budget for our juveniles. We don't have a budget for the staff that supervise them, the caseworkers, the mental health staff, or the correctional professionals that are charged with overseeing them. But because we have to keep them separate, we have a separate place where we house them. So I hope that answered your questions. And if you have any further questions, we're certainly available.
Thank you so much, Mr. Wickham. Appreciate that. Well, let me ask if I have any questions for Mr. Wickham while we have him here on the Zoom. Assemblywoman Cohen, please go ahead.
Thank you, Chair, and thank you, Mr. Wickham. I guess what I'm just trying to get at is trying to understand. I understand somewhat about PREA and I understand about sight and sound separation, but are these considered? Once a juvenile goes into DOC, are they considered wards of the state where beyond what the state is required to do to care for prisoners, that technically we're caring for them as minors, as wards in our care versus just prisoners in the state's care? Do you get that difference that I'm trying to understand?
Yes, for the record, Harold Wickham, Department of Corrections. Yes, through the chair to the Honorable Assemblywoman Cohen. Yes, when they come into the system, they are certified as an adult, as I don't like the word prisoner, but as an offender. They're certified. They're under the same sentence structures as the adults in the prison. It's just because of PREA, we are required to keep them separated, segregated from the typical adult populations that would tend to try to victimize or anything like that. So yes, they are treated exactly the same. They come under the same sentence structure as from the court as any other offenders. Hope that answers your question, ma'am.
Thank you.
Thank you again, Mr. Wickham. Appreciate you answering those questions. Seeing no additional questions at this time, Senator Orrin, I'll ask you to hold tight for a moment. We'll take some testimony on the bill, and then we'll have a chance for concluding remarks before we close the bill hearing. At this time, I'll open up for... Hold on. Still getting used to this in-person yet virtual world. So thank you for your patience, everybody. I'm going to open it up for testimony in support of Senate Bill 357. Let me first ask, is there anyone joining us on the Zoom today who would like to testify in support of Senate Bill 357? If that is the case, if you could turn your camera on, unmute yourself, and simply let me know that you'd like to offer supportive testimony. And we'll give it just a minute. Okay, I don't see any activity, see or hear any activity on the Zoom, so at this point we'll go to the phone lines. BPS, could we go to the phones and see if there's anybody there who'd like to offer testimony in support, please?
Yes, Chair. To testify in support of Assembly Bill 357, press *9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 037. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. Good morning, Chairman Yeager and members of the Judiciary. We would like to thank the sponsor, Senator Orrin, for bringing this bill forward. We'd like to say that to separate these children, it would be instrumental in preventing any undue influence by an adult. It also becomes a hardship for the families and for the juveniles when they're separated and placed out of state, or due to the phone calls. As you've been told, they have are treated the same as the adults, and so we do support this bill. Anything to bring families closer together instead of separating them would be wonderful. It would help with adjusting for the juveniles and the families, and prepare them into the prison system as an adult, instead of just throwing them into the wolves, so to speak. So anyways, we do support this bill. Thank you.
Thank you for your testimony and support, Ms. Brown. BPS, could we take the next caller in support, please?
Yes. Would the caller with the last three digits of 695 slowly state and then spell your name for the record? You will have 2 minutes and may begin.
Good morning, Chair Yeager. This is Holly Wellborn, HOLLYWELBORN, Policy Director for the ACLU of Nevada. First, I want to apologize to Senator Orrin and to the committee. This bill popped up quite quickly. I did present this bill with the Department of Corrections and Senator Orrin over in the Senate, and we're glad to see that it so quickly already made it over to your committee. I want to just back up and paint a picture on where these bills come from and how we've been involved in this process. And I first want to say that this has been very much a partnership between the ACLU of Nevada and the Department of Corrections. All stakeholders agree that the Lovelock Correctional Center and any adult institution is the wrong place to house youth, whether or not they have been transferred or direct filed to the adult criminal justice system. I just submitted to the committee secretary a report that the ACLU of Nevada drafted. We went to every facility in, most juvenile facilities and the Lovelock Correctional Center youth pod multiple times and did a minimum practices assessment on those institutions to determine, their fitness for children. And the conclusion, of course, was that the juvenile institutions are a better fit. And out of that arose a study that led to the drafting of a package of bills that will be before your committee in the coming days. So SB 357 is a critical part of that, to start looking at exactly how much it costs to house young people. Deputy Director Wickham explained that currently they're not tracking juveniles and what the expenditure is, and that information is necessary and pertinent in order for us to determine whether or not there might be able to be some sort of cost-sharing agreement between the DOC and between the Division of Child and Family Services in order to start finding alternative housing placements for young people. So that's the background and idea of the bill. And, as we go through this legislative process, you'll see that, there are some plans to establish a pilot program to house some of these youth in a juvenile facility. But we're very much in agreement with a lot of the questions that were asked, and agree with Assemblywoman Krasner that it's time for us to start moving away from this system, particularly in an era with where life without parole for juveniles has been abolished through the Supreme Court and through statutes here in Nevada. We have to treat our youth like youth in order to have the best possible outcomes when those young people leave prison. So this is a part of that process. I can remain on the line if there are questions for me. I'm more than happy to take questions via email or meet with any of you if you'd like more details on our study and where we're going with this program. Thank you, Chairman Yeager.
Thank you for your testimony, Ms. Wellborn. Appreciate you being on the phone and being available. And committee members, if you do have questions for Ms. Wellborn, I would invite you to reach out to her. I will assure you that she'll be very responsive to any of those questions. BPS, do we have additional callers on the phone in support of Senate Bill 357?
Yes, we do. Would the caller with the last three digits of 080 please slowly state and spell your name for the record? You will have 2 minutes and may begin.
Hi, Jim Hoffman, representing Nevada Attorneys for Criminal Justice. NACJ supports SB 357 because we believe that no child should be housed in an adult prison. This bill is just about gathering data on that practice, but more data is always good. And I wanted to speak specifically to Assemblywoman Krasner's concerns, because the main way that adult prisons protect kids from being physically attacked is to keep them physically isolated. They have to stay in their pod for the vast majority of the week, because if they leave, then all of the adult prisoners have to go on lockdown. This is, of course, very expensive and difficult for the prison as a whole, so it doesn't happen very often. This causes all kinds of problems for the kids. They get limited access to exercise, to fresh air, limited access to classrooms for school or other kinds of programming, and so on. So the kids are physically safe in most circumstances, but it really comes at the cost of their ability to do all of these normal kid things that help them work through their problems and be rehabilitated. Holding kids in adult prisons is setting them up to fail. SB 357 doesn't directly fix this problem, but it gives us better information so that we can do a better job of fixing it later on. NACJ supports that, and so we support this bill. Thank you.
Thank you for your testimony, Mr. Hoffman. BPS, are there additional callers in support?
Yes, we'll now go to the caller with the last three digits of 611. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. This is John Pirro from the Clark County Public Defender's Office. We'd just like to echo our support and say that we agree with the statements by the ACLU and NACJ that came before us, and like to thank Senator Orrin Shaw for bringing this bill forward.
Thank you for your testimony, Mr. Pirro. BPS, additional callers in support?
Yes, we will now go to the caller with the last three digits of 318. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary. This is Kendra Birchie, BERTSCHY with the Washoe County Public Defender's Office. I want to thank Senator Orrin Shaw for bringing this very important bill. As you've heard us say all session, that unfortunately Nevada is a data-dry state, and this is one additional way that we can ensure that we are enacting policy based off of data-driven solutions. So we appreciate this bill and urge your support. Thank you.
Thank you for your testimony, Ms. Birchie. BPS, do we have additional callers in support?
Yes, we'll now go to the caller with the last three digits of 377. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning. My name is Deshaun Jackson, DASHUNJACKSON. I work with the Children's Advocacy Alliance as the Director of Children's Safety and Welfare Policy, and we support Senate Bill 357. Thank you all so much.
Thank you for your testimony, Mr. Jackson. BPS, are there additional callers in support?
We are currently taking testimony in support of Senate Bill 357. To provide testimony, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I will close testimony in support. We'll now open it up for testimony in opposition of Senate Bill 357. Do we have anybody on the Zoom who is in opposition of the bill? If so, would you please unmute yourself and simply let me know you'd like to speak? I don't hear any activity on the Zoom. BPS, could we go to the phone lines to see if there's anybody there in opposition?
To testify in opposition of Senate Bill 357, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I will close opposition testimony. I will now open it up for neutral testimony. Do we have anybody in the Zoom who'd like to testify in the neutral position? I don't see or hear activity on the Zoom. BPS, could we go back to the phones to see if there's anybody there in neutral?
To testify in the neutral position on Senate Bill 357, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I will close neutral testimony. Senator Orrin would like to give you a chance now to make any concluding remarks on Senate Bill 357.
Thank you, Chair Yeager, members of the Assembly Judiciary Committee. Appreciate your taking the time to hear Senate Bill 357. I think this information will be of paramount importance to the Interim Committee on Child Welfare and Juvenile Justice, the future legislatures, to try to make the right decision for these children. I think these children, like all children, can receive treatment, and there's a lot more that can be done in terms of rehabilitation versus what currently is attempted to be done at the Nevada Department of Corrections. I appreciate all their work and what they're doing for those kids, but I believe that there's information here that we can get that will help future legislatures make important decisions to try to improve outcomes for these children. Thank you for your time, and thank you for hearing the bill.
Thank you so much for being here this morning, Senator Orrin. Again, it was a pleasure to see you, and we hope you have a really great rest of the day, and I'm sure we'll see you around in the building.
Thank you very much. Honored to be here.
Hey, committee, so I'm going to close the hearing on Senate Bill 357. We're going to go ahead and take Senate Bill 161 next. So at this time, I'll open the hearing on Senate Bill 161. Senate Bill 161 eliminates the Advisory Committee to Study Laws Concerning Sex Offender Registration and transfers its duty to the Advisory Commission on the Administration of Justice. That was a bit of a mouthful for a bill description. But I want to welcome back to the committee Ms. Adair from the Attorney General's office, and I also believe we have Ms. Brady with her as well. We can see you both on the Zoom, so welcome to the in-person committee hearing through virtual means. And when you're ready to proceed with the presentation for Senate Bill 161, please go ahead.
Good morning, Chairman Yeager, Jessica Adair for the record. And yes, I am joined by my colleague, Senior Deputy Attorney General Katie Brady. I do want to give credit where credit is due. This is a bill sponsored by Senator Spearman, and I don't know if she is able to join us this morning, but I am happy to present the bill and explain why we had recommended this change to the Sunset Committee over the interim. The Advisory Committee to Study Laws Concerning Sex Offender Registration had quorum. The committee did thoroughly and substantially alter or repeal the Adam Walsh Act as it applies to adult offenders. Registration continues to be an important topic for examination, but the committee's narrow scope leaves out many other critical issues, such as lifetime supervision for offenders, pre-sentence psychosexual evaluations conducted by the Division of Parole and Probation and their effectiveness, recidivism rates and reduction, prevention of sexual offenses, victim services, offender services, and others. Another important feature of the Advisory Committee Another important feature of the Advisory Committee is the lack of certain stakeholders in its membership. The statute does not require a representative of the Department of Public Safety or the Central Repository, the Department of Corrections, the Department of Parole and Probation, or the State Board of Parole Commissioners. These agencies play a critical role in the implementation of any sex offender registration requirements. It is for these reasons that the Attorney General's office recommends the continued study of sex offender registration laws within the Advisory Committee on the Administration of Justice. Thank you. I'm now able to take any questions.
Now, normally, Ms. Adair, we would make all presenters identify themselves for the record, but I'll leave it to our committee secretary to figure out how to annotate that one. But thank you for bringing some real life and some levity into our hearing. We do appreciate that, and we appreciate the struggle. We've all been there. So,
Mr. Chairman, I have a question for the dog.
I sincerely apologize, and I hope to be more professional in the future.
It's completely fine, Ms. Adair. We understand. So why don't we go to Ms. Brady? If you'd like to make any remarks on the bill as well, please go ahead.
This is Katie Brady for the record. I am a Deputy Attorney General with the Nevada Attorney General's Office. I've been involved in some of the litigation, and I'm here to answer any questions, should there be any questions regarding the sex offender litigation. Thank you.
Great. Thank you so much for being here, Ms. Brady and Ms. Adair. Do we have questions for either of our presenters? I don't think questions for the dog are going to work well on Zoom. Assemblywoman Kasama, please go ahead.
Thank you. Yes, it's a fun world with our Zoom, and I appreciate the presentation. My question is that we're adding in here to identify and study issues relating to the state and federal law concerning the registration of sex offenders and any litigation concerning these laws. We were already tracking all this before, right? Were we already doing it, but this is just putting it in statute that it needs to be done? I just assumed we were already doing this.
Thank you for the question, Jessica Adair for the record. Yes, we absolutely were. And so this committee was put in statute 10 years ago. What we're recommending is that these duties don't change. They simply move from this advisory committee that had a very narrow scope and narrow membership to the ACAJ. The ACAJ has a larger statutory membership. It also has a much more comprehensive scope to look at sex offender registration laws, but also lifetime supervision, victim services, all of the other things that go into a more comprehensive look at how we treat offenders of sexual crimes when they are released from incarceration. So yes, Assemblywoman, you're absolutely correct. We have been tracking this all along through this committee, and we're not recommending that we end these duties at all. They simply transfer to the Advisory Commission on the Administration of Justice.
Thank you so much.
Do we have additional questions for Ms. Adair or Ms. Brady? I do not see additional questions at this time, so thank you to the two of you for presenting. I'll just ask you to hold tight for a few minutes. We'll see if we have any testimony on the bill, and then we'll come back for concluding remarks. So at this time, I will open it up for testimony in support of Senate Bill 161. And let me first check on the Zoom. Is there anyone on the Zoom with us who'd like to testify in support? If so, if you could please unmute yourself and let me know you'd like to testify. I don't hear any activity on the Zoom. BPS, could we go to the phone line to see if there's anybody there in support?
To testify in support of Senate Bill 161, press star 9 now to take your place in the queue. Once again, to testify in support of Senate Bill 161, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close testimony in support. I will now open it up for testimony in opposition. If we have anyone on the Zoom in opposition, if you could please unmute yourself and let me know you'd like to speak in opposition. I don't hear any activity on the Zoom. BPS, could we go back to the phone lines to see if there's anybody there in opposition?
To testify in opposition of Senate Bill 161, press star 9 now to take your place in the queue. Again, to testify in opposition of Senate Bill 161, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I'll close opposition testimony. I will now open neutral testimony. If there's anyone on the Zoom with us in neutral, could you please unmute yourself and let me know you'd like to speak? I don't hear anyone indicating they'd like to speak on the Zoom. BPS, could we go back to the phones to see if there's anybody there in neutral, please?
Yes, to testify in the neutral position on Senate Bill 161, press star 9 now to take your place in the queue. Once again, to testify in the neutral position on Senate Bill 161, press star 9 now. Chair, there are no callers in the queue.
Thank you so much, BPS. I'll close neutral testimony. Ms. Adair, would you like to make any concluding remarks on Senate Bill 161?
Thank you, Chair. I would just also add the Attorney General is a statutory member of the ACAJ, so we look forward to working with you. I know many other members of the committee are also on the ACAJ. We look forward to working with you on these critical issues. And I look forward to testifying in person starting next week, where I can do so without any assistance.
Thank you so much, Ms. Adair. We appreciate your presentation. And Ms. Brady, thank you for being here for any questions. We hope you have a really good rest of the day. And honestly, we really needed that kind of levity this morning. So thank you for sharing with us, and we'll see you soon, I'm sure. At this point, committee will close the hearing on Senate Bill 161. That takes us to the first bill listed on the agenda. I will now open the hearing on Senate Bill 32. Senate Bill 32 makes various changes relating to offenders with substance use or co-occurring disorders. And I believe we have our guests from the Nevada Department of Corrections here, Mr. Wickham and perhaps a couple others who I believe are going to present Senate Bill 32, and then we will have a chance for questions. So welcome to our presenters, and when you're ready, if you could please go ahead with your presentation on Senate Bill 32.
Good morning, Chair Yeager, Vice Chair Wynn, and esteemed members of the Assembly Judiciary Committee. My name is Maria Job, M-A-R-I-A-J-O-B, Substance Abuse Counselor 3, Clinical Supervisor for Substance Abuse Programs for the Nevada Department of Corrections. I'm here to present Senate Bill 32, SB 32, which revises the provisions governing certain programs of treatment for offenders established by the Director of the Department of Corrections. A similar bill was previously submitted during the 80th legislative session as SB 49, and at that time an amendment was introduced that had the unintended impact of increasing our fiscal note for Nevada Department of Corrections from $0 to $844,600, and then $1,044,492 in the following biennium. The recommended changes submitted in SB 32 again bring with them a current $0 cost. This amendment seeks to clarify and update the current verbiage in Chapter 209 of the Nevada Revised Statute and meets current evidence-based programming practices that we provide within our facilities. This bill defines these programs as program of treatment for offenders with substance use or co-occurring disorders. The term substance use disorder is defined as a cluster of cognitive behavioral patterns and psychological behaviors indicating that the individual will continue to use substances as listed in the Diagnostic Statistical Manual of Mental Health Disorders, 5th edition, or the DSM-5. In addition, the term co-occurring disorders is defined as the presence of at least one mental disorder and at least one substance use disorder as defined by the DSM-5. As stated earlier, the language included within this bill is more in line with what is considered acceptable within our field and will match what services we are already providing within our department. This update in verbiage will also allow us to qualify and apply for additional grant funding that will provide us the opportunity to not only improve our current programming efforts, but to expand statewide programming to include co-occurring programs. These changes are necessary in order to provide a continuity of care for releasing offenders, continue our recidivism reduction efforts, improve treatment for incarcerated offenders, and reduce long-term costs to the state of Nevada. This concludes my presentation and am available for any questions you may have.
Thank you so much, Ms. Job, for your presentation. Appreciate you being here this morning. Do we have questions for Ms. Job on Senate Bill 32? Assemblywoman Cohen?
Thank you, Chair. Thank you for the presentation, Ms. Job. If it's okay, I've got multiple questions. So in section 9, sub 5, am I reading that an offender has to be within 2 years of the expected release date? So if there's an offender with who needs these programs, but their release date is longer out, is there anything for them? Because don't we want them treating? Doesn't that save us money in the long run if they're getting the proper treatment, even if they're 5 years out or even 10 years out?
Thank you for your question, Assemblywoman. Yes, the program is specific to the end of their sentence due to the fact that research predicts that they, once they receive the treatment at the very tail end of their program, then once they release, they'll have that information to themselves to carry on into the community, versus if they were to have the program at the beginning of their sentence, then throughout their treatment or throughout their stay at NDOC, that information may get lost or may not have the same effect as if they were, once they were leaving prison.
Thank you. But so are there other programs for them, for people that are longer out from their treatment, from their release? Are they getting anything if they're 5 years out, 10 years out?
Yes, there are a variety of other programs within NDOC, substance abuse programs specifically at the tail end of their sentence.
Okay, thank you. And then what is the practice as far as throughout the language? Throughout the bill, there's language about the director and the director making decisions. And I'm sorry, I'm not trying to put you in an awkward position because I know this is your job and the director's your boss, but how much is mental health care? How much of these decisions are being made by the mental health care providers versus the prison officials who aren't necessarily trained in mental health care?
Maria Jobe for the record, NDOC. The substance abuse programs and mental health providers, the information is directly provided to the inmates by those by the staff members. So the director just places us in those positions. It's the mental health and the substance abuse are provided by those providers.
Thank you. And I wasn't trying to imply that non-mental health care providers were providing it, but I mean, who's making the decision about if an inmate needs treatment and what treatment they need?
Thank you for your question. Maria Jobe, NDOC. Substance abuse providers and mental health providers make those decisions. There's a criteria that they have to meet in order to come into our program, and those are set forth by both mental health and substance abuse programs.
Okay, thank you.
We'll go next to Assemblywoman Gonzalez.
Thank you so much, Chair. Assemblywoman Gonzalez, District 16 for the record. What is the purpose and goal of reducing the time in programs? And would the aftercare programs be shortened in this process as well?
Thank you for your question. Maria Jobe for the record. The shortening of time frame, what we do currently is our programming meets current criteria. The reason for aftercare is because that's what research suggests, is that if it's a shorter amount of time, then they have to get into the community and program beyond the walls of the prison. That answers the question.
Thank you so much. I have a few. I'm so sorry. So research suggests, that's a great point. Are there any research out there that suggests or supports moving in this direction?
Thank you for your question. Yes, there is. I don't have it here in front of me, but I can provide that information.
Thank you. And then my last question, is it the intent of the bill to provide services and help the inmates, or is it more about cost?
Maria Jobe for the record. Thank you for your question. The bill is just to clarify language. We are currently doing these things, therefore we wouldn't change anything that we're doing. This is just to update the verbiage of the NRS, that's all.
Thank you.
Do we have additional questions from committee members? Ms. Job, let me ask you one. Obviously, we're not a money committee, but my interest was piqued a little bit when you indicated there was a prior piece of legislation that resulted in a rather large fiscal note, and I believe you'd indicated that you thought that was an unintended consequence, and this bill essentially was to kind of clean that language up. At a very high level, could you just give us a sense of what was the issue in the prior legislation that generated the fiscal note, and how does this language fix that problem?
Thank you for your question. Maria Joe for the record. The difference before was it specified and mental health disorders. Currently, it's the language that we suggested say or co-occurring disorders. So if you say and, it requires an entire package deal of another additional program staff members, additional program requirements. It's an entire package deal versus what we're doing currently, which is create a substance use disorder or co-occurring disorder. So it's both instead of a mandatory and. I hope that makes sense.
It does make sense. Thank you for that response. Committee members, last call for questions on Senate Bill 32. I don't see additional questions. Ms. Job, thank you for presenting. I'll ask you to hold tight. Excuse me, we do have one more question from Assemblyman Orrin.
Thank you, Chair. If we could just follow up on Assemblywoman Cohen's question, just to focus this a little bit. Somebody comes in, they have a 5-year sentence, they have a substance use disorder. They're not eligible for this particular treatment for their substance use disorder until 3 years later. So what kind of treatment do they get for their substance use disorder when they enter the prison in their 5-year sentence?
Thank you for your question. Maria Job for the record. The Department of Corrections provides a variety of different programming, and substance use is specific to the tail end only because that information may get lost on them while they're in their first 3 years. And then say if they entered prison, got substance use programming, and then went back out into the general population, that information would not be as available to them, or it wouldn't be used as much as if they were going straight to the community and having that community surround them in at the end of their sentence. So they have a variety of other programming available to them, not substance use specifically.
Okay, may I follow up? So I appreciate that why it's important for to be close to their leaving to remember, but they're still suffering from a substance use disorder while in prison, and that may affect their conduct and behavior while they're in prison. So what programs are there for that?
They have mental health available Maria Job for the record. Thank you for your question. They have mental health available to them. They have other programming. I'm not going to say specifically which ones because I don't want to misspeak on all of them, but they have a variety of other programming available to them as well. So it's not just that they're left to do nothing. They have a variety of other options available to them, and then they can catch hours at the very end to enhance what they've already learned.
Thank you.
Assemblywoman Hanson.
Thank you, Chair. Just to expand a little bit on this conversation about a treatment program 2 years out from release, I'm trying to understand the logic of it, and to me it's making sense that, and having had family members who have suffered with substance abuse issues, so they're incarcerated, say, for 5 years out from their release. And you're saying that we want to do it closer to their release because it will be fresher in their mind, they'll be more dialed in, and when they're incarcerated, they aren't exposed, hopefully, to the issues that they're going to have once they're released. They're not going to have access to alcohol or drugs and the substances that have been a problem when they're not in prison. So you're saying they might not have it available to them as soon as they need? Are you saying that the 2 years is justified because maybe some of the substance abuse programs have shown success in a certain period of time? Do we have any data, and this might not be within your scope of work, but do we have any studies that show we have success when we do a program, a substance abuse program, within a certain framework of time?
For the record, this is Deputy Director of Programs Harold Wickham. If I may, I'd like to respond to that, Chair, if that's all right.
Please go ahead.
Through the chair to the Honorable Senator. I'm the Deputy Director of Programs. We have a great deal of programs for offenders. And typically when they come into the facilities, we do an assessment. We call it the NRAS, the Nevada Risk Assessment Test. We give them an assessment, and then we determine what programs are best suited for the offender for the best outcomes based on evidence-based practices. And some of those classes are like AA, NA, Narcotics Anonymous, things like that. But also there's a lot of programs that offer necessary skills prior to getting into substance abuse programming, such as moral recognition therapy, thinking for a change, getting it right. And these are the kind of the precursors to get to the substance abuse programming. While all of these programs involve, making good choices, ancillary things that relate to substance abuse, evidence-based programs suggest that it's best to provide the therapeutic communities as we get closer to release, and that way it continues to create that. When they move out into the communities, they have the continuum of care from leaving a therapeutic community right out into community-based programs with our community partners. And I hope that answered your question now.
Thank you for clarifying.
Thank you, Mr. Wickham. Additional questions from committee members? Okay, going once. Assemblywoman Gonzalez, you want to ask another question?
Thank you so much, Chair. Assemblywoman Gonzalez, District 16 for the record. In sections 1 through 4 or 5, it talks about inmate accounts and money. Are we making these inmates pay for their programming?
Thank you for your question. Maria Job, substance use programs for NDOC. No, they are not required to pay for their treatment.
Thank you.
Additional questions? I don't believe I see any additional questions. Let me look one more time as we get used to this in-person world. It's a little bit harder to see when you're not on the screen raising your hands. Okay, I don't see additional questions. Ms. Job, Mr. Wickham, thank you for presenting, and we'll again ask you to sit tight for just a moment while we take some testimony, and then we'll have a time for concluding remarks. At this time, I'll open up the hearing for testimony in support of Senate Bill 32. If we have anybody on the Zoom who'd like to testify in support, please unmute and just simply let me know that you'd like to speak on the bill. I don't hear any activity on the Zoom. BPS, could we go to the phone lines to see if there's anyone there in support?
Yes, to testify in support of Senate Bill 32, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 037. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Tanya Brown. TONJABROWN, Advocates for the Inmates and the Innocent. We support this bill. I think it would be beneficial in the long run for the inmates under this bill. That's all I have to say, and have a great day. Thank you.
Thank you for your testimony and support, Ms. Brown. BPS, do we have additional callers in support?
We're currently taking testimony in support of Senate Bill 32. Press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close testimony in support. We'll now open it up for testimony in opposition. If there is anyone on the Zoom joining us who would like to testify in opposition, please unmute yourself and let me know you'd like to speak. I don't hear any activity on the Zoom. BPS, could we go back to the phone lines to see if there's anybody there in opposition, please?
Yes. To testify in opposition of Senate Bill 32, press star 9 now to take your place in the queue. Once again, to testify in opposition of Senate Bill 32, press star 9 now. Chair, there are no callers in the queue.
Thank you, BPS. I will close testimony in opposition. I will now open it up for testimony in the neutral position. If there is anyone on the Zoom who'd like to testify in neutral, would you please unmute yourself and let me know you'd like to testify? I don't hear anything on the Zoom. BPS, could we go back to those phone lines one last time to see if there's anybody there in the neutral position?
To testify in the neutral position on Senate Bill 32, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 080. Please slowly state and spell your name now. You have 2 minutes and may begin.
Hi, Jim Hoffman, Nevada Attorneys for Criminal Justice. NACJ is testifying in neutral on SB 32. This bill gives more discretion to NDOC in how to treat offenders with substance abuse problems. Discretion can be a double-edged sword. This could be used as a way to do a better job of treating offenders, but it could also be used as a way of cutting costs on the back of prisoners. We believe that Deputy Director Wickham is committed to using this discretion in a positive way, but in a longer-term sense, we are concerned that different leadership could use this discretion in a negative way. Therefore, we are testifying in neutral to note these concerns for the record. Thank you.
Thank you for your testimony, Mr. Hoffman. BPS, is there anybody else who'd like to offer neutral testimony?
We're currently taking testimony in the neutral position on Senate Bill 32. Press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, BPS. I'll close neutral testimony. Ms. Jobe, I would hand it back over to you at this time if you'd like to make any concluding remarks on Senate Bill 32.
I appreciate you guys hearing the bill today and thank you for your time.
Thank you, Ms. Jobe. Appreciate your patience this morning, and Director Wickham, appreciate you being here as well. Thanks for spending some time with us on this Thursday morning, and we hope you have a fantastic rest of the day. So I will close the hearing on Senate Bill 32. Committee members, that brings us to the last item on our agenda, which is public comment. By way of reminder, we reserve up to 30 minutes for public comment at the end of each meeting. Public commenters will have 2 minutes to provide public comment, and public comment is a time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. Let me first check with those who are joining us in the room as guests. Would anybody like to give public comment in the room? Mr. Vieska, any public comment this morning? Okay, public comment is waived in the committee room. BPS, could we go to the phone lines and take public comment there, please?
To make public comment, please press star 9 now to take your place in the queue. Once again, if you would like to offer public comment, press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 556. Please slowly state and spell your name for the record, and you will have 2 minutes.
Marie Grant, ANNEMARIEGRANT, sister of Thomas Purdy, murdered by Reno police, hogtied and asphyxiated then by Washoe County deputies. Tomorrow at 8 a.m., Clark County Government Center, there will be a public fact-finding review in regards to the murder of 25-year-old Jorge Antonio Gomez. He was murdered by LVMPD on June 1st, 2020 while attending a Black Lives Matter protest while exercising his First Amendment rights. He was out there supporting families like my own who have lost a loved one to police brutality. Please attend to watch the hearing via the YouTube link, which I'll send by email. There is no expectation for true justice for Jorge. You should all be aware the Clark County DA, Stephen Wolferson, has never charged one single officer or ruled a police murder of a community member unjustified. Sergeant Ryan Fryman fired 7 lethal rounds, Deanne Emerton 4, Officer Vernon Ferguson fired 3 lethal rounds, Andrew Locker fired 5. 19 lethal rounds were fired at Jorge. Jorge was not out there fighting for himself. He was out there as an ally to support the injustices that are happening. Now us families who already have known this heartache fight for him, and I will stand as an ally until my last breath for Jorge's family, my family, and all families affected by police violence. We need real change and real consequences for anyone who takes a life. Wearing a badge and gun should not protect a murderer. Promoting FBI investigations, federal mediation, federal receivership, civilian review boards, body cameras, racial sensitivity training, and other methods like these as a way to defend the community against police brutality. These methods are not designed to prosecute police, but rather to restore public confidence in the police. They are used to diffuse demands for prosecuting police brutality and minimize punishment for guilty cops. It's time to follow suit like New Mexico and Colorado and end qualified immunity for police. If anything, those who have the ability to take a life and currently without consequence should be held to a higher standard. We've given them armored vehicles, bulletproof vests, robots, shields, stab vests, etc., yet community members are still being tried, convicted, and executed by police. Change is needed right now. Thank you.
Thank you for your public comment, Ms. Grant. BPS, are there additional callers for public comment?
To make public comment, press star 9 now to take your place in the queue. Chair, there are no callers in the queue.
Thank you, as always, BPS, for helping us through the testimony by phone. I will close public comment. Anything else from committee members this morning before we talk about where we go from here? All right, well, I want to say it was very nice to have you all in the same committee room. You're probably feeling a lot like me. This feels very unusual given the last year, but I think we'll be able to work through it as we move forward. And thanks to our staff for making this happen as well. It's another wrinkle for broadcast services to have a committee room to broadcast as well as Zoom and telephone. So just want to say that we appreciate all the work that you're doing and your ability to adapt to these ever-changing circumstances. In terms of where we go as a committee, we do have an agenda for tomorrow. It'll be a 9 o'clock start. We have 3 bills on the agenda, but I'm confident we'll be able to get through those in a timely manner. Agendas are out for Monday and Tuesday. We do not have committee meeting on Monday or Tuesday. That is in anticipation of long floor sessions to make sure that we get the bills out before the deadline on Tuesday. I do anticipate we'll have committee meetings Wednesday through Friday of next week. I don't know what we'll do yet because we're waiting on a lot of bills from the Senate, but we'll ramp up again after Tuesday. So we'll see you back here in this room at 9 a.m. tomorrow morning. I hope you all have a wonderful day. This meeting is adjourned.